Hello, everyone, and welcome to our webinar, Applying for BJA's Adult Drug Court Discretionary Grant, What You Need to Know. Thank you for taking time out of your busy schedules to learn more about this process. My name is Steve Collins, and I'm a Senior Program Associate at the Justice Programs Office at American University. This webinar is being brought to you by the National Drug Court Resource Center, the go-to place for drug court practitioners to access a wide variety of resources to ensure their programs operate as effectively as possible. The Resource Center can be visited online at www.ndcrc.org. Before we get started, I want to go over how the webinar will work today. All attendees are currently muted. If you have a question during the webinar, please submit it using the Q&A panel located on the right side of the webinar screen. We have set aside a few minutes towards the middle and at the end of today's webinar to address any questions that come up. If you have a question that we are not able to get to, there will be a brief survey at the end of the webinar that includes an option to submit additional questions. We would appreciate it if you could fill out the survey even if you don't have any questions. It will help us improve future webinars and should only take a minute. Today's webinar is being live captioned. To access this feature, just click on the Multimedia Viewer tab on the top right of your screen. As a final note, this webinar is also being recorded, and the video will be posted on the Justice Programs Office YouTube channel and on the Resource Center website. With all that covered, it's my pleasure to introduce Greg Torain. Greg currently serves as the Drug Court Policy Advisor for the Bureau of Justice Assistance, or BJA, and will be presenting today's material. Take it away, Greg.
All right, thank you, Steve. Hello, everyone, and welcome to today's Adult Drug Court Discretionary Grant solicitation webinar. Again, this is Gregory Torain, the Policy Advisor for the Adult Drug Court Program, and excited to have you all on today. I'll just jump right on in. So today we'll be overviewing the funding for the Adult Drug Court Program. We'll talk about some of the goals of the Drug Court Program, as well as some of the administration's priorities for the Drug Court Program. We'll go over the eligibility requirements, the funding categories. We'll review application sections of the grant. We'll talk about some of the top 12 application tips preventing issues for delays for you accessing your funds post-award. And we'll go over some of the grant solicitation resources. And in between the time, we'll also have a Q&A halfway through and another Q&A at the end. So the Adult Drug Court funding has been receiving a lot of new funding, as you can see from the history of the Adult Drug Court funding history. So as of from 2016 to 2019, the budget has increased, looks like to about $51 million. That appropriation is in between both the Adult Drug Court as well as the Veteran Treatment Court. So there's two appropriations of the entire Adult Drug Court program. So the appropriations is broken down, like I said, into two appropriations that makes up the $99 million. $77 million is for adult drug courts, and $22 million is for the veteran treatment courts. The funding for the Adult Drug Court Discretionary Grant Program funds both training and technical assistance as well as site-based awards. As you can see, the first bullet talks about our planning initiative training that provides training to drug court teams that are seeking to implement a drug court program. Also, we're looking to, in terms of our site-based or make awards this year to both individual drug courts as well as states, looking to make at least about 96 awards, in between 90 or 100 that we're looking to make this year. Also, we provide free training and technical assistance through these funds, as well as the National Drug Court Resource Center, which Steve talked about just a little bit earlier in terms of providing a lot of different resources on that website, all things related to drug courts. In terms of webinars, previous webinars, publications are listed on that website. So the overall goal of the drug court program is to equip courts and community supervision systems with the necessary tools and resources utilizing the most current evidence-based practices and principles to intervene with participants who abuse substances while preparing them for success in their communities. Like I mentioned earlier, some of the priorities of the current administration are listed here. One thing to note in terms of the priorities, when you're submitting your application, Most of our funding is also tied to the administration priorities as well, so you want to make sure you infuse these priorities within your application. The first being administering a comprehensive strategy that addresses the opioid crisis as well as prevent overdoses. You want to support law enforcement and other criminal justice partners in reducing and preventing crime. Promote the use of evidence-based strategies to reduce recidivism as well as substance abuse among drug offenders. We want to ensure that veterans have access to services and focusing on post-traumatic stress disorder, and prioritizing funding to rural and high-poverty communities. And lastly, establish a sustainability plan that moves past initial implementation into long-term viability. So again, as you write your applications, you want to make sure that you infuse the priorities within your application. So then you know the application was released February 14th and it closes April 16th, which gives you a little over 7 weeks, close to 2 months to apply. So who may apply, or what are the type of applicants that we're looking for who can apply for the drug court program? So is adult drug courts is a type of grant. There's a DWI or DWI courts, co-occurring courts, tribal illness and wellness courts, as well as veteran treatment courts, and also for hybrid courts. So if you're looking to apply both as an adult drug court and as a veteran treatment court, you may apply under 2 of the combined 5 court categories. But please look at the note at the bottom. Please provide the percentage of funding designated for each court if the combination includes a veteran treatment court. So you have to make sure that you demonstrate the percentage of funding that you will be applying for each one of those if you're combining them. Also, a thing to note when you look at the Veterans Treatment Court, under the Adult Drug Court Discretionary Grant Program, there is a prohibition for violent offenders. The exception is for Veteran Treatment Court. So if you are looking to apply as a Veteran Treatment Court, you would be able to apply to serve violent offenders. And there's 2 types within the application where that's indicated. It's type A and type B. Type B is where you're able to provide services to offenders who've been charged with a violent offense. All right, categories. So we have 3 categories within the drug court program. Category 1 is for implementation, 2 is enhancement, and statewide. So an applicant is eligible for a BJA grant if it is currently receiving federal funding for a part of its drug court program. However, the applicant will be disqualified if the request federal funds for the same focus area or court type as an active BJA adult drug court. So what this means is if you currently have an active BJA grant or even an active SAMHSA grant that has the same focus as the one that you're applying for, then you would be ineligible to apply. Meaning if you currently have a veteran treatment court that's serving a certain population that's active, and then you apply for another for the same grant or the same veteran treatment court, then you would be ineligible to apply. But if you currently have an adult drug court and then you're applying for a veteran treatment court, that same fiscal agent would be able to apply. So eligibility requirements. So if you're applying for Category 1 implementation or Category 2, eligible applicants are states, state and local courts, counties, and units of local government, as well as federally recognized Indian tribal governments. And for Category 3, it's limited to state agencies such as the State Administration Agency, the Administration Office of Courts, as well as the SSA. For implementation, applicants may request up to $500,000, and that's over a 48-month period. So a lot of times we get questions related to, is the $500,000 every year? The $500,000 is over the period of 48 months. And these grants start between October 1st to January 1st of 2020. And implementation grants are for jurisdictions that are in the process of completing a planning process. And operational pilot programs may apply. Allowable use of funds for implementation, you can use it for core operational services, participant supervision and management, and provisions of coordination of recovery support services such as housing, placement assistance, and job training. To learn more about some of the examples of recovery support services, please visit page 47 of the solicitation. Category 2 enhancement. An applicant may request up to $500,000, and again, that's for a period of performance of 36 months. So again, $500,000 over the 36 months. Same start date, and these are for jurisdictions that have been fully operational at least a 1 year, and that for this solicitation, the 1 year period would be September 30th of 2019 that you would have to be fully operational to apply. And you must demonstrate a compelling need for additional federal funding. You can use enhancement funding to scale up your program capacity. You may be looking to increase the number of individuals that you're serving. So if you're serving 20, you may be wanting to serve 40 or 60. Enhance court services, improve quality and intensity of services, or even expand or enhance the current services that you have, conduct evaluations, as well as develop or implement and management information systems in terms of using the enhancement funding. Then we move over to statewide. Again, this is limited to state agencies to be able to apply. We have two subcategories within statewide, that's subcategory A and B. The total amount of funding that you can receive through the statewide is $2 million for state-based services, coordination services. For subcategory A, you can receive up to $500,000, and for subcategory B, it's $1.5 million. For subcategory A, that is for 36 months, and for subcategory B, that's 48 months. Again, has the same start date of October 1st through January 21st of 20. And we encourage you, if you're looking to apply for statewide, you can apply for both subcategory A and B for the $2.2 million, but you also can apply for them separately. And again, this is limited to state agencies, and you must demonstrate a compelling need for the federal funds. Allowable use of funds for subcategory A, looking to improve or enhance or expand drug court services statewide in terms of expanding the evidence-based programs and principles through the NADCP standards, as well as other activities. Also, statewide training and technical assistance to improve your drug court functioning, and establishing statewide automated drug court data system and performance management systems that these funds can be used for subcategory A. For subcategory, also for subcategory A, and this is new this year, funds may also be used to develop and or expand a state-based TTA program that supports the TTA needs of the drug court statewide. You will be able to use your funds to scale up your statewide capacity to support personnel required to coordinate a state-based TTA, which means that for states, you would be able to use the subcategory A funding to expand your TTA or maybe have staff or personnel throughout the state of whatever state that you're in to be able to identify local needs or in rural communities, what are their TTA needs, and be able to use these funds to have personnel to be out there to be able to provide technical assistance throughout the state. So it expands the work that you'll be able to do in terms of providing TTA throughout the state. And subcategory B is to support drug courts in local and regional jurisdictions that don't currently receive or operate with BJA funding. It's important to know if you're receiving subcategory B and the state applies for that, and that's for the $1.5 million, that money has to go directly, pass through the state, and go directly to the local and regional drug courts that are identified in the application to be funded. And again, subcategory A is for the $500,000.
Great. Thanks, Greg. Do you want to answer a few questions now?
Yep, let's take questions now.
All right, and just a reminder, if anyone has questions, please submit those to the Q&A panel to the right side of the webinar screen. All right, so Greg, the first question we have, for a program that's currently in a no-cost extension on a drug court enhancement project funded through this mechanism, is it possible to apply again for a similar focus for this round?
Yes, I know the issue. I know if you're in a no-cost extension, which means you still have an active grant, so you wouldn't be able to. I mean, if you were in a position where you were looking to take the no-cost extension, well, in this situation, if you have a no-cost extension, you wouldn't be able to apply because you would currently have an active grant.
Great. Another question regarding this kind of line of thought. If a program that has a current BJA grant that ends at the end of September of this year, and if they have a new focus such as treatment, are they eligible to apply?
Yes, if a fiscal agent is applying, they have a grant and it ends before the start of this grant, then those two grants would not be active at the same time. They would be able to do a different focus, or they would also be able to do the same focus just because those two grants wouldn't be active at the same time.
All righty. Our next question. If there's a team or a program has a hybrid adult drug court DUI court, and they do not operate with grant funds, are they eligible for the enhancement grant?
If they don't have current federal funds, yes, they would be able to apply.
Great. And we have another question here asking if you could describe in a little more detail what is considered a Operation Pilot Program.
Well, operational pilot program would be, I mentioned that during the implementation category. So if you are currently in the process of developing or having a pilot program looking to start an implementation drug court program, that would be a pilot program. If you already had you were already in the planning stages and were in the process of being able to make that next step to apply for an implementation grant, you have a team in place and you've pretty much put together the organization or have the team in place, then that would be considered a pilot.
All right. The next question is, can enhancement funding be used for housing assistance?
Yes, that would be under the Recovery Support Services, where you can see examples of that information on page 47 of the solicitation. So you got to keep in mind, though, for Recovery Support Services, you can use up to 25% of the overall budget of the grant. Once you become a grantee, and if you become a grantee, then you could request from your program manager to go over the 25% limit. But when applying, you have to stay within the 25% of the budget can be for Recovery Report Services.
Great. Next question is, we have a drug court that's been operational for 2 years and a veterans treatment court that's been operational for 2 months. Can we apply for both Category 1 and Category 2?
So you have a veteran treatment court. So you would, for the adult drug court, you would have to apply for, if it's operation 2 years, then that would be applying for an enhancement. The veteran treatment court would be then applying for the implementation. So yeah, you would be able to apply for both implementation and enhancement for those two different type of courts.
All right. And are probation departments eligible to apply on behalf of a DWI court?
The probation, if it fits within the eligibility that's indicated in the solicitation, whether it be state or local government, then they would be able to apply. Keep in mind, though, and I haven't gotten to it yet in the solicitation, if they meet the eligibility requirement and they're not the actual drug court, there is a form that I'll mention a little bit later, the fiscal agent, MOU fiscal agent document, which would require, well, actually on the slide that we're getting ready to go over, that they would have to make sure they fill that out, because we want to make sure that if an agency that's not the drug court is the fiscal agent, that they're working collaboratively with the actual drug court program. But if they do fall in within the eligibility requirements, then they would be able to apply.
All right. Then a question regarding the statewide grant. If applying for Part A and Part B of the statewide grant, Is the page limit still 20 pages, or would it be 40 pages?
No, it would still be 20 pages.
All right.
And please stay within the 20 pages as well.
All right. And we have a number of questions coming in, Greg. How long would you like to do this Q&A for?
Yeah, no, we can jump back in because we're halfway through, so we can say those questions and move through the rest of the presentation, and then we can follow with the last questions.
Okay, and I'll just make a quick note that if we don't get to all your questions, we will, after the webinar, we'll get answers for you and we'll send them out to everyone that registered for the webinar.
All right, thanks, Steve. So continuing on, there's 3 important notes to make, and I was getting ready to mention one earlier, but I'll get to that as I go through the 3 listed here. Activities, when you're applying, activities should be clearly connected and related to activities that are criminal justice related, and the primary focus of this solicitation is not for treatment resources as well as post-release or support medical services. Again, it's more of a criminal justice related drug court solicitation. And under the solicitations, you should primarily use support of overall goals and objectives of the drug court program, as well as support efforts to adhere to the evidence-based principles, which includes the NADCP best practices, as well as the 10 key components, as well as an entity applying for Category 1 and 2 on behalf of a drug court must attach a fiscal agent MOU that describes the applicant's effort to coordinate directly with the drug court for which funding is being sought. The MOU must address the overall goals and objectives of the drug court program, as well as support efforts to adhere to the evidence-based program principles included in NADCP best practices, as well as 10 key components. Again, what that means is, and it kind of addresses that one question, if you're applying for both or either an implementation or enhancement, and you're not the drug court, and if you're the fiscal agent, whether you're a local county government or state agency, what have you, well, it's not related to state agency, but if you're a local government applying on behalf of the drug court program, you do or would need to do a fiscal agent MOU coordinating your service with the actual drug court program. Okay, cost associated recovery support services, and I think that was one of the questions as well. You are encouraged to provide recovery support services. And again, no more than 25% of the budget can be used for recovery support services. And if you become a grantee, you would be able to increase that limit, but you have to receive prior approval and provide justification for why you need to increase service for recovery support services. And again, page 47 is where you see a number of the examples there. Prior consideration. So with the Adult Drug Court Grant for Category 1, prior consideration is provided to applicants who have completed the BJA Drug Court Planning Initiative or the NHTSA's DWI Court Foundational Training. To learn more about those, you have 2 web links that you can visit to learn about how you can go about participating in those trainings. And again, those are for implementation of either an adult drug court or a DWI court, as well as we have those also for veteran treatment courts, as well as tribal illness and wellness courts. And then for Category 1 and 3, priority consideration is given to applicants within their product design section that propose strategies that are inherent with the 10 key components, as well as NADC best practice standards. Okay, there's 2 requirements here as a part of the grant. The first being that you must demonstrate that the drug court understands and agrees that to the extent that the substance abuse treatment and related services are funded by this award, that you will include treatment service to address opioid abuse and reduction. BJA has clarified this with our Office of General Counsel that funding is not limited to opioid abuse reduction. Applicants may focus on serving offenders with addiction to other drugs and alcohol in addition to addressing opioid abuse reduction. What this means, and we get a lot from different jurisdictions, that opioid is not our issue in our jurisdiction or in our state or where we're at. Do we have to focus on that? The solicitation is pretty much saying that because this is coming from the President's budget under opioids, that you do need to indicate in your application having a strategy to address the opioid issue, as well as being able to demonstrate to provide services for individuals who come to your program or your drug court program that have opioid use disorder, but you're not disqualified for funding if opioid is not the issue that you're seeing in your jurisdiction. And also the applicant must demonstrate that drug courts for which funds are being sought will not deny eligible applicants who are currently taking FDA medication or FDA approved medication. Application sections. So there's 9 sections within the application that you'll have to complete. The first being the SR 424, the federal government application form. Then there's the program abstract. Some of these you will see I have required on them. So these are critical pieces of the application that you definitely have to make sure that you provide as a complete part of your application. If not, where you see required, if you do not provide that information, the application will not make it through the beginning screening process. Project narrative, you need to have that. Budget detail worksheet and budget narrative is required. Then you have the indirect cost rate, tribal authorization resolution, financial management and systems of internal controls questionnaire, as well as the lobbying. And there's also additional attachments that we'll go over on the next slide. So some of the additional attachments, and I want to make this clear. So when you are applying and you're creating your attachments, it's always beneficial for those that are reviewing these applications or the peer reviewers that when you do your attachments, please clearly define what it is that's going to be in the attachment. So if you have an attachment that's the time task plan, please indicate that in the name of that attachment, which makes it easier. And if you are doing the attachments, be sure to have individual attachments for each one. I know in the past we have sometimes people submit them with the time task plan along with the letters. It makes it a little harder for the peer reviewers to find. Whenever you have someone reviewing, you want to make that as easy as possible for them. So again, the time and task plan is required. We also talk about the MOU, which is signed by all team members, as well as it can be signed by a designated agency representative. It's just what works for your agency. But that form should have the rules and responsibilities signed off by each of the team members indicating their role. Then we talked a little bit already about the fiscal agent MOU. We recommend that you have letters from the SSA and also letters from the state court administrator. If applicable, if you have a policies and procedures manual, please attach that. Disclosure of pending applications. It's important to make us aware as a form or attachment to indicate if you currently have applications pending. Let's say Stanford already has their application or their grant out. If you submit an application with them, you would need to indicate that in the applicant disclosure form. Research and evaluation, independence and integrity, as well as the request of justification and employee compensation waiver, if applicable, is a part of that, those attachments, again, if applicable. Okay, the program abstract. So things that you will notice that you will have to complete within the program abstract is you need to indicate the category for which you are applying. You also need to indicate whether you are urban, suburban, or rural. And the best way to identify that, I get that question a lot, it can be easily determined by your geography, which is the geography that's defined by the U.S. Census Bureau. You need to indicate whether you're a pre or post adjudication. Again, the type of court that you're applying for, whether it's co-occurring, adult drug court, or veteran treatment court, you need to indicate that. It's important to have the name and location of jurisdiction or the point of contact for the grant. Again, the amount that you're requesting, and it should not exceed the category. One thing also to note when you're putting the total amount of requested funding, the funding that you have on the abstract should match the total amount of funding indicated on the SF 424. Also, the same amount should be indicated in the budget. Next, the current capacity and increased capacity. So if you need to indicate here, if you're currently serving 20 and you're looking to increase that to 40, that also be indicated in the abstract. Participants proposed to receive services, your target population. Also, you need to affirm what are the best practice standards that you will be meeting and indicate pages where that will be discussed in the narrative. So here you want to talk about which of the best practice standards you will be addressing. Again, you want to indicate the pages where that is identified in the program narrative, as well as data collection mechanisms. Important to note at the bottom, so there is a provided template for the program abstract. It's only limited to 400 words. And we give you up to 800 to be able to complete the abstract. So if you run out of space on the template, you can do an attachment, but remember to label it as abstract. Okay, so part of the narrative, this is very important. It seems small, but it's very important. This indicator on top, it needs to be double-spaced using standard 12-point font, 1-inch margins, and please do not extend beyond the 12 pages, and remember to number the pages. These are the sections of the solicitation or of your, not solicitation, I'm sorry, of your application. Be the statement of the problem, where you clearly define what the problem was within your jurisdiction. That category or that percentage is equal in each of the 3 categories, which is the 20%. The project design or implementation section, you have to talk about your overall strategy for implementing your drug court. That's 40% in each of the categories. The capability and competency, that is related to your drug court staff and all the services and the skill level of the staff that will be providing the services. That's at 20% for each of the category. And then plan for collecting data that's required for the solicitation. For the performance measures, that's at 15%. And then the budget is at 5%. It's important to note, though, when peer reviewers we are reviewing these applications, a lot of times the first thing that people go to is the actual budget to make sure the budget reflects what's in the project narrative. The budget speaks a lot because it actually tells us what you're planning to spend your money on. But make sure that that budget is consistent with what you have in the project narrative. Okay. It's also important, any qualitative and statistical data provided in the program narrative must be verifiable and recorded in official record, that being whether it's crime statistics, arrest statistics, recidivism. We're going to use that data in the program narrative to determine whether the applicant's level of need or program capacity is being met, and if we are able to manage the grant by ensuring that you have that verifiable information or data. Your data is verifiable. Okay, budget and budget narrative. Again, this is required. You definitely make sure you have to have this as a part of your application. It should be itemized for each of the years. If it's for 36 months or for 3 years, it needs to be for that. If it's for the 4 years or 48 months, it needs to be indicated for that. It does require a 25% match, and match can be a combination of cash as well as in-kind. There's no minimum required for the amount of cash match. Do not report any overmatch in the budget. However, you can discuss that overmatch in your narrative. Applicants should budget to have up to 3 team members attend up to 2 BJA approved conferences. And you can see, if you want to know which are some of the approved trainings, please visit the NDCRC link that you see there. And prior approval is needed in order to planning and reporting of conference meeting and training costs. Okay, the time and task plan, again, is required. In the time and task plan, it should be outlining your goals and objectives, summarizing your major activities, expected data completion, who would be responsible for completing those tasks, all should be a part of that time and task plan. Okay. the memorandums of understanding as well as letters of support. So I think I mentioned this a little bit earlier. So for the key drug court members, you need to also include what their responsibilities are as a part of that attachment, which is the MOU for your court members. Also mentioned this a little bit earlier too, the fiscal agent MOU. So I won't go over that again. Again, we also have the SSA's letters. They should include confirmation that the proposal conforms to the framework of the state strategy of substance abuse treatment. And then you have the state court administration letters. They should describe how the proposed application would enhance statewide efforts related to problem-solving courts and part of the state problem-solving court strategy. So we recommend that you have those in there. They're not required, but only one that's required, if applicable, on this page is the fiscal agent MOU. All right, getting down to some of the top tips for preventing your application from getting delayed once you receive an award. Starting with the first one, it's part of the SF-424. The legal name and tax ID or address entered into the 424 should be for the legal entity that will be receiving and managing the funds. Please review carefully the information to complete the application for federal assistance on page 15. A lot of times we get applications come in and there's different names. You have the tax ID name or the legal name, and then we have a drug court name, and it can slow that process down. Tip 2 relates with SAMs. When processing your award, OJP uses SAMs to confirm active registration and verify the legal name and address entered into the SF-424. Now, if SAMs registration is not active at the time, we've got to conduct a search of the legal name and address does not match the application, then we have to put a hold until that issue is resolved. Tip 3, the authorized representative listed on the SF-424 should be the official with authority to sign and accept grant applications for the legal entity which is applying. That person should be one of the highest elected officials or appointed administrative officials. OJP will use the internet to confirm prior to award if someone else in your agency has been delegated authority to sign the award documents. And you should attach your application to a letter of delegation on the agency letterhead signed by the highest elected official. Moving on to tip 4, and I think I mentioned this earlier, the total federal request entered into SF-424 should match the total federal request in your application budget for the entire 36 or the 48 months, depending on your category which you're applying. And even in addition to that, should be also indicated in the abstract. Budget for FY29, it is required that the budget and detail worksheet template that is linked to the solicitation of your application. If you use a different format, it is possible to receive an award, but you will not be able to access your funds until the proper format is submitted and approved post-award. So you'll see within your application, there is a link where you can pull up that format. Please definitely do that, and because if you don't, then obviously it'll delay the process. Then allowable costs, please do not use or please do not include any of the costs listed in the unallowable use for award funds, section page 14. That section is on page 14, I'm sorry. If such costs are identified in your application budget and you receive an award, you will need to revise your budget before receiving funds. Tip 7, the budget template has been revised to distinguish between subgrants versus procurement contracts. You should pay careful attention to the guidance on page 19 to properly categorize your costs in this section. Tip 8, refer to the cost sharing or match requirements on page 12 of the solicitation. 2 key things to note: all matches cost items must meet the same allowability guidelines as the federal cost items. And if you exceed the required minimum match amount, Any amount over will be required and subject to audit once your budget is approved. Then tip 9, follow exactly what an application should include section beginning on page 14. It is very helpful for reviewers if each attachment in the separate file named number as it is in the solicitation. If you combine attachments, please include table of contents with that page numbers. So again, for reviewers that are reviewing this, again, you would make it as easy as possible for them to find documents. And it's also good if you have your attachments, like I mentioned before, if you have time and task plan, label that attachment that. And if you have maybe 10 extra attachments, develop a table of contents so it makes it easier for the reviewer to be able to identify where he needs to look or she needs to look to find that. Tip 10, note that is required that all applications, whether you have duplications to declare or not, see page 25 in the solicitation. And this is related to the disclosure of pending applications. I think I mentioned a little bit earlier. Again, like if you have, you submit an application with SAMHSA or you submitted another drug court application somewhere, you want to make sure that you indicate that in the disclosure attachment form. And then tip 11, if you are proposing to use grant funds to pay an outside evaluator, this attachment is required. See pages 26 to 27. And then the last tip with the program narrative, all projects funded under this solicitation or program must be able to address opiate reduction. This should be reflected in the program narrative per the language within the solicitation under each category. So again, like I mentioned, this is funding comes from the president's budget for opioids, so you definitely need to indicate your strategy to addressing opioid reduction. Then now moving on to some of the BJA grant resources. Like mentioned earlier, the National Drug Court Resource Center is pretty much a website with a repository of many drug court related things that you can find on various topics, webinars and things of that nature. You can find numerous publications. You can find this, you'll find eventually this webinar listed on there, or all things drug court will be listed on the NDCRC. Also within the NDCRC website, you'll see grant solicitation resources. After you're done with this webinar, please visit the website to learn more about the best practice standards. You'll see the drug court 10 key components, the veteran 10 key components, the tribal illness, the wellness key components, as well as we have samples of previous program narratives of successful applications. We'll also have on there where you'll also be able to see some of the common questions that were asked during last year's webinar, solicitation webinar. If you don't get your question answered immediately, you would be able to go to that and reference some of the questions that others have asked in the past, along with the ones I'll get today and I'll respond to today. And then we'll move on to questions. So we're ready for questions, Steve.
All right, and we have a number of questions. So Greg, just let me know when you reach your limit, and until then, I'll just keep throwing them out your way.
Yeah, no problem.
All right, our first question. Our judicial district does not currently have a drug court. So what needs to be approved, in place, or passed, and by what relevant authorities before applying or being able to apply for this grant? So they don't currently have any planning process. You don't really have any, in order to apply for an implementation or an enhancement grant, or if you don't have anything in place now, you would have to refer back to your state or your county to identify what you need to do to put things in place to be able to start your drug court program. What we do through the adult drug court planning, through the drug court program, is that we do provide courts that are ready to begin that planning process with training to set them up to be able to be in a position to apply for an implementation grant. So that's something that they may have to look within their state or their jurisdiction to find out what they need to do in order to set their individual drug courts up. All right. And then a follow-up question relating again to the operational pilot program. Does that mean that when a small new adult drug court with around 5 members, could they still apply for a Category 1 implementation grant?
They would be able to apply if they've been operating less than a year, yes.
All right. And now a question regarding Montana. So under Montana statutes, adult drug treatment courts can take violent offenders. Does this mean that they cannot receive funds or they must limit the funds to nonviolent offenders?
If they're going to be, the prohibition means that if they're going to be applying for the BJA drug court grant, then they would not be able to provide services to violent offenders or receive federal funds. What they may be able to do if they did apply for a grant, they would have to use funds that are not federal funds or connected to BJA funds. They would have to use other state funds or whatever they have. They would have to also be able to show that they're not using BJA federal funds unless they were doing a veterans treatment court, which would allow for the exception.
Okay. And Greg, that includes match funds, correct?
Yes, match funds. Yep, that includes both match funds and federal funds. Yep.
All right. And then we have a question or a request that you explain the fiscal agent and fiscal agent MOU in a little more detail if you can.
Okay. So the fiscal agent is the person who's actually applying for the grant. So the fiscal agent MOU would be to, if you're applying for implementation or enhancement, and the fiscal agent is a local government, the fiscal agent, if the fiscal agent isn't the actual drug court applying, it's another agency applying on behalf of a drug court. Let's say I'm a county agency, and I feel we have a drug court, they're looking to start, and we want to apply for an implementation grant to assist that drug court, then I would need to, as a county or local government, do a fiscal agent MOU because I'm not the actual drug court, but I'm looking to apply on behalf of that drug court program. The whole goal is really to ensure that the agency that's applying or the fiscal agent that's applying on behalf of the drug court is working in coordination with the actual drug court program.
All right. And do applicants need to attach policy and procedural manual with their application for implementation grant?
No. No. And again, even with enhancements, it's applicable. If you don't have one, you still can apply, and if it's a good enough application, obviously you'll be awarded. But it's if you have one, and for implementation, they're not required to or to have one. Yeah.
All right. And can match from another federal agency count for the match on this grant?
You know what? I have to get back on that one. I don't want to give the wrong answer to that one. I have to get back on that. I have to. That may be a part of our fiscal, our frequently asked questions. I have to get back on that because I have to get back on that one. I don't want to give a wrong answer on that.
All right. And just to answer a few questions I've been seeing about whether this presentation will be available, both the recording as well as the slides will be available after the webinar, I would say within the next week or so. And so they'll be available both on the Justice Programs Office YouTube channel as well as the National Drug Court Resource Center website. And we'll email a copy of all that as well to anyone that registered or participated in the webinar. And the next question. Okay, it says, will you please revisit the comment that this is a criminal justice focused, not treatment focused? Does this mean that we cannot apply to pay for things like salary for case managers with treatment providers?
No, what that means is, no, you would be able to do that. What it just means is that BJA Drug Court is a Department of Justice drug court program, which means that if you're applying specifically for only treatment or other services, That's not what this grant is for. It's for the overall operations of your drug court program, which can include recovery support services as well as treatment. So no, they would be able to, if that is enhancing or expanding their services by hiring a staff to do work that will enhance their program, then they would be able to do that.
Okay. Does a 25% match required need to be above and beyond what is being spent on the existing drug court program?
No, it just need to be 25% of what they're requesting. So if the example is within the on page 12 of the solicitation. So if they're applying for up to $500,000, then they need to demonstrate a 25% match of that, an additional of that.
Okay. And just for clarification, if our drug court has an existing SAMHSA grant, would we not be eligible to apply for this grant?
It depends. If your SAMHSA grant is active and it will be active at the start of this grant, that doesn't necessarily would block you out. But if it's the same target population, if it's the same focus, then yes. If your SAMHSA grant is focusing on veterans or is focused on co-occurring or is it focused on young adults and you're applying with BJA for a different target population, then you would be apply. You wouldn't be able to apply if it's the same target population. What we don't want to do is have two of the same grant, active grants doing the exact same thing.
Okay. All right. If I run a DWI court and would like to submit a grant to increase capacity for our program, which is DWI defendants only, is my DWI court still eligible to apply for funding even though we don't target opioid users?
Yeah, you would if you're not currently receiving BJA funding for your DWI court and you're wanting to apply for funding for DWI, you would be able to apply. Again, if your target population or your issue is not opioids, you still would be able to apply. It's just that you need to also indicate in your application a strategy to provide services for individuals who may come into your program who have opioid use disorder.
All right. If our fiscal agent receives federal funding for other programs that would that count as receiving federal funds eligibility to apply, even though the VTC operates on a medical college grant?
I think I understand the question. So if the current funding that you have, if the fiscal agent is not, if they're not currently receiving a BJA drug court grant, then you would be able to apply. If they're receiving funding from somewhere else that's supporting the veteran treatment court, then you would be able to apply with BJA for veteran treatment court as a fiscal agent. So yes.
Okay. And another question about the abstract. Is the word limit 400 words or 800 words?
It's 800 words. In the solicitation, it says 800 words. The issue is that the project abstract, that template that we provide, limits to 400 words. So you can do 400 words, but we give you up to 800 words that you can do your abstract. And if you need, like I mentioned earlier, if you need more than 400 words, then you would need to include an additional attachment and label that as program abstract and include that as an attachment of the application.
All right. So this individual who's asking questions performed process and outcome evaluations for various drug courts over the years. This year, the agency he or she works for will be involved in the drug court program. Does this exclude them from providing evaluation services?
So can you say that again? I'm sorry, Steve.
Sure. So this individual has performed process and outcome evaluations for various drug courts over the years. This year, the agency that they work for is going to be involved in the drug court program. Does that exclude them from providing evaluation services to that program?
No, I don't believe that would exclude them. That would probably be the partnership that they have with the drug court program. I don't believe that would exclude them for being able to provide services to a drug court program that is receiving drug court funding.
Okay. How, if at all, are rural drug courts prioritized for the solicitation?
How is well, if you submit your application and you would indicate in the abstract that you are submitting an application and you're supporting a rural, you're in a rural community, we would look at that as an area where, based off the administration priorities, that we want to continue to support or provide funding to those areas if those areas submit, or if the application is obviously a really good application, is very creative and application that we receive. Again, it has to be peer reviewed, but it would also, it's one of the things that we're looking at in terms of providing support to rural communities. So it would be something that they identify based off their geographical defined U.S. Census Bureau that they are a rural community. Then it would be something that we look at in terms of making decisions after it goes through the strenuous peer review process. So it doesn't just jump ahead or anything. It has to go through a strenuous process. All other applications does, but it's something that we look for.
Mm-hmm. Another fiscal agent question. Do the fiscal agents have to be a government agency?
Well, a fiscal agent would have to be what's indicated in the solicitation in terms of who is eligible. Again, that would be states, territories, state, local courts, counties, and units of local government, and federally recognized tribes would be who would be eligible.
All right. Looks like we have one more question. Oh, we're still getting questions in. Is there any priority between a single office applying as a fiscal agent, such as Indigent Defense Services, for an enhancement grant to enhance and improve their services and operations, or is an application from the drug court prioritized?
Well, the only priority considerations are what I mentioned earlier in the presentation in regards to one for implementation grantees doing prior planning and participating in the BJA Drug Court Plan Initiative planning program, as well as the NHTSA's DWI foundational training. Other priorities would be in their project design, addressing the NADC best practice standards, as well as the key components. So those would be the primary priorities. It wouldn't be whether you were a state or local government or a drug court applying. We wouldn't prioritize that. Those wouldn't be the priorities.
All right. And can family drug courts, are they still eligible for this funding?
No. These funds are only for the types that was indicated in the solicitation, that being adult drug courts, co-occurring courts, tribal illness wellness courts, DWI courts. Family drug courts wouldn't be funded through the Adult Drug Court Discretionary Grant Program. I would recommend that they follow up with the Office of Juvenile Justice and Delinquency Prevention, who do provide funding for family drug courts. And I think they have a solicitation either out or coming out pretty soon.
All right, Greg, I think that's about it. Thank you for all this great information. I'm sure the information and guidance you provide today will be a big help to these programs that are applying for the funds. Again, before we conclude today's webinar, I just want to remind everyone to please fill out the brief survey that will appear in your web browser shortly. It should only take a minute and will help us to improve future webinars. If you have a question that we were not able to get to today, or you're looking for additional clarity in the answer, please, you can submit those to us as part of your survey response. So there's a question there where you can submit additional questions, and we'll compile those all after the webinar, create an FAQ document, send it out to everyone, as well as post it on the Resource Center website. So thank you again, everyone, for participating in today's webinar. And Greg, if you have any last words, it's all yours. Otherwise, I think that's it.
No, I'll just say good luck to everyone. Really looking forward to some of the creative applications that come in. And again, good luck, and thank you for participating in today's webinar.
Great. Thank you, Greg. Thank you, everyone, and have a great day.
All right. Thanks, Steve.